3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the sweetheart deal and tested what the records could actually prove without speculation. Today, we are examining the immunity list and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is the confidential addendum to the 2007 non-prosecution agreement, which named 4 alleged co-conspirators who received immunity from federal prosecution.
This document really is the anchor for everything that followed.
Without it, the timeline doesn't make sense.
It's incoherent. What we're looking at is a legal instrument filed in the Southern District of Florida, the non-prosecution agreement, the NPA.
Now, in a standard procedure, an NPA is for cooperation.
Right. You use it to get a target to give you information in exchange for some leniency.
Yeah.
But the structure here, it's different. It contains an anomaly.
The confidential addendum.
Exactly. That addendum extended protections beyond just Jeffrey Epstein.
Yeah.
It shielded specific third parties.
Okay, so let's identify those parties. The document is explicit.
It is. It lists 4 individuals by name: Sarah Kellen,
Adriana Ross,
Leslie Groff, and Nadia Marcinkova.
And these aren't just random names. When you take this list and cross-reference it,
You see an immediate pattern.
we checked it against the Epstein flight logs unredacted and the DOJ's own report from the Epstein case documents.
And they are not just passengers. That's the key distinction. The forensic review of those flight logs places them in a constant operational orbit around Epstein.
They're on flights between New York, Palm Beach.
Paris, the USVI, that's the U.S. Virgin Islands. It's persistent.
But it's the DOJ report that gives the context for why they're on this immunity list.
Yes, the government had evidence. The document suggests these individuals were facilitators. They handled the logistics of the trafficking operation.
So by naming them in the NTA,
The prosecution effectively froze their legal status. It took them off the board as targets.
it completely halted the ability to charge them. The text of the agreement is clear. They received immunity from federal prosecution for any crimes related to the Epstein investigation in that specific district.
The Southern District of Florida
It converted them from potential defendants
into protected figures. And this wasn't a temporary shield.
No, it was indefinite, as long as they held to the terms.
It created what you could call a zone of immunity. Normally, if you're a co-conspirator, you are trading information for a plea deal. You're giving something up.
Right, you cooperate.
Here, the records show what looks like a preemptive shield. We don't have documentation showing that these 4 provided substantial, actionable evidence against Epstein back in 2007.
So the kind of evidence that would warrant such a complete and total shield from prosecution.
Correct. Based on the public filings we have in the Pinpoint database, the transaction appears asymmetrical.
Let's drill down on that asymmetry. You take someone like Sarah Kellen.
Yes.
In the Epstein flight logs unredacted, her name appears with a frequency that almost rivals Epstein's himself.
It's constant.
The logs show her coordinating travel. She's often listed next to notations in the scheduling books like females or massages. The DOJ report references these.
And the immunity she received wasn't for a single act.
No. It covered the entire conspiracy, the whole duration of the criminal enterprise up to that point in 2007.
And that duration is critical. We're not talking about a few months. The conspiracy allegation in the filings covered years of activity.
So by immunizing the schedulers, Kellen, Groff, Ross,
You're immunizing the people who understood the day-to-day mechanics of the operation.
the operational layer.
Exactly. In a typical RUACO case, a racketeering case,
Yeah.
you leverage the scheduler to get the executive. You work your way up the chain.
Here, the opposite happened. The executive at the top secured immunity for his schedulers.
The documents suggest the priority was containment of the case. It wasn't about dismantling the organization.
So let's widen the aperture from these 4 named individuals, because they're significant, but they aren't the part of this document that generated a decade of legal warfare.
No. That comes from the clause covering people who are not named.
I'm looking at the record EFTA ADO 0001050 is in a PDF from the Pinpoint database. The NPA extends immunity to, and I'm quoting directly, any potential co-conspirators of Epstein.
And that is the structural anomaly. that phrase, any potential co-conspirators.
Let's break down the language.
When you audit a legal settlement, specificity is what you look for. It's the gold standard. You list the people, the entities you're releasing from liability to avoid any future ambiguity.
This does the opposite.
It intentionally does the opposite. It creates a blanket of protection for a completely undefined class of people.
It's precise in its vagueness.
It is. It essentially says, if you could have been charged as a co-conspirator in this specific jurisdiction for these specific crimes, you are now immune.
And the word choice is critical. It doesn't say known co-conspirators or indicted co-conspirators. It uses the word potential,
which implies a theoretical category. It's not about who the prosecutors knew about. It's about anyone who could have been a target. If a prosecutor could theoretically make a case against you, you're covered.
It creates a paradox.
It does. To be protected by this agreement, you have to fit the definition of someone who broke the law with Epstein.
If you were innocent, you wouldn't need the immunity.
And if you were guilty, the immunity prevents you from ever being prosecuted.
It's a closed loop.
Airtight.
Yeah.
And it effectively shut down the ability of the Southern District of Florida to pursue anyone else, the entire network.
And the government attorneys, they knew this was unusual language.
The record shows they did. The correspondence in the pinpoint database, specifically EFTA 00000062546.pdf, it tracks the legal maneuvering they used to justify it.
This is where the defense team brings in a Supreme Court case.
Yes. Johnson v. Yellow Cab Transit Co. That citation is critical. It shows the sophistication of the legal strategy being deployed.
So what was the argument?
They used the Johnson precedent to argue that this non-prosecution agreement, signed in Florida, could bind the entire U.S. government globally regarding the specific set of facts.
So a deal in one office in Florida could stop an investigation in New York or California.
That was the goal. They were trying to preserve the rights of these unnamed potential co-conspirators by arguing that you didn't need to list all possible actors if the category itself was broad enough to cover them.
Let's break that down, because that legal argument is what defined the next 12 years of this case.
It is.
The defense was arguing that one U.S. attorney in one district had the authority to bind the entire Department of Justice.
That was the interpretation Epstein's legal team pushed for. The term they used in the negotiations, it's in the documents, was global peace.
Global peace.
They wanted to ensure that once this document was signed, that was it. No loose ends, no other jurisdictions, no other U.S. attorneys' offices popping up later with indictments.
Against the financiers, the recruiters.
Or the high-profile associates. The Johnson case was the legal lever they used to force that interpretation into the final text of the agreement.
And this created an accountability gap, a huge one.
A gap that persisted until the 2019 indictment in the SDNY, the Southern District of New York.
We have that transcript, the notice of filing transcript from USA v. Epstein, dated July 2019.
And in that filing, the New York prosecutors explicitly challenge this reading. They take the formal position that a deal signed by a U.S. attorney in Florida cannot and does not bind the Southern District of New York.
They had to argue it didn't apply to them.
That friction is the defining tension in the case files for more than a decade, from 2008 to 2019. You have one federal office, Florida, that had closed the door on any further inquiry.
And then a decade later, another office, New York, had to find a way to legally pry that door back open.
They did that by arguing the Florida agreement was procedurally flawed or constitutionally limited just to that district. But for 12 years, that unnamed clause worked. It was a functional firewall.
So during that entire time, this whole class of potential co-conspirators operated with the understanding that they were shielded.
The document, EFTA 0000507.pdf, is clear. It bars criminal charges. It was a standing order against prosecution.
And it worked.
The outcome proves it worked.
Huh.
Between 2007 and 2019, look at the record. Despite the flight logs being known, despite victim testimonies in civil cases, there were 0 federal indictments of any co-conspirators.
The firewall held.
The legal architecture of that addendum successfully prevented the criminal case from ever expanding.
So we have to understand the decision logic. Why would federal prosecutors in the Southern District of Florida ever agree to language that was so broad?
The Epstein file release specifically document 1332-16 and some of the pinpoint entries that give us a window into the timeline.
And what does that timeline suggest?
The documentation points to one priority above all others.
Closure.
Just ending the case.
The correspondence suggests that by granting this blanket immunity, the office could terminate what was becoming a very sprawling, very complex, multi-jurisdictional investigation. It's simpler. If you immunize the entire network, you no longer have to investigate the entire network.
Precisely. It consolidates the case down to one single plea by Epstein. He registers as a sex offender, serves a short sentence, and the rest of the file is effectively sealed.
When you read the email chains in the record, it reads like administrative exhaustion.
Yeah.
They wanted the case off their desk.
They framed the plea deal Epstein's registration, the 18 months in jail, as a win. The immunity for everyone else was simply the price of securing that win.
But the price was also privacy for the network.
Yes, the document EFTA 00002888E0.pdf is very revealing on this point. It notes that the NPA, quote, does not purport to list each person. Instead, it uses the broad classification to, quote, avoid specific enumerations.
Avoid specific enumerations, that's the phrase.
It is. It's a tacit admission. They're saying that listing out the individual names would be too problematic.
Too explosive. You can't put out a government document that lists names like Prince Andrew or Les Wexner or Jean-Luc Brunel as co-conspirators receiving immunity.
The public scrutiny in 2007 would have been overwhelming. So instead of a list of names, they used a generic legal category.
It was a way to provide the legal benefit of immunity without the public relations cost of identification.
Exactly. It allowed the high-profile associates to remain anonymous to the public while being fully protected by the legal agreement.
But there is a massive documented failure in this process, and it concerns the victims.
It does.
I'm looking at EFTA 02335898.pdf. This document references the victims list, P005420, and it confirms the sequence of events.
The sequence is damning.
The immunity deal for the co-conspirators was being negotiated, finalized, and signed before the victims were ever notified about the plea terms.
Which is a direct violation of the Crime Victims' Rights Act, the CVRA.
It's not ambiguous.
No. The DOJ's own review of the closure of the investigation confirms this exact sequence. The deal was done. The immunity for both the named and the unnamed co-conspirators was locked in. Only after all that was finalized were the victims told that the federal investigation was over.
So it wasn't just a failure to notify them, it was a structural exclusion. They were locked out of the process at the most critical moment.
The CVRA mandates that victims have a right to confer with the government's attorney, to be heard.
By sealing the deal first, the government denied them that right. They couldn't object to the immunity clause.
Because they didn't even know it existed until it was a signed contract.
And this timeline, it's not speculation, it's indisputable in the records.
The signature dates on the NPA precede the notification letters sent to the victims' attorneys. It proves that the decision to immunize the entire network was made in a closed room, without the input or even the knowledge of the people harmed by that network.
So this brings us to the core question. Who actually benefited from this unnamed clause? The document didn't list them, but the flight logs, the unsealed depositions, they give us a roster of people who were in proximity to the crimes.
They'd occupied that potential co-conspirator space.
We need to map those actors. Let's start with Prince Andrew.
The shocking revelations, source summary, and the Epstein case documents are the primary records here. His name, Prince Andrew, appears 76 times in the documents we reviewed.
And we see him in the Epstein flight logs unredacted. He isn't just a name on a passenger manifest. The logs correlate his travel with specific allegations made in depositions.
Yes. Jane Doe, #3, in her testimony, describes activities involving Prince Andrew in London, in New York, and on the island in the USVI.
So this is where the NPA becomes directly relevant to him.
For years, his legal team relied on the argument that he fell under that potential co-conspirator umbrella.
That if he was a potential co-conspirator, he was immune from prosecution in Florida. It was a defensive shield.
And a very effective one. He didn't have to admit any guilt to use that shield. He just had to argue that the definition in the agreement could apply to him.
It's a strategic use of the ambiguity that was written into the document.
It is. In the civil cases brought against him, his lawyers argued that because the 2007 deal covered any potential co-conspirator, it barred the victims from suing him. He effectively lived inside the loophole created by that clause.
Then for a long time it worked. The DOJ did not reopen an investigation into him during the period the NPA was considered binding.
The immunity deal provided a plausible legal defense against any attempt to interview him or charge him in the United States.
Okay, next name, Bill Clinton.
The shocking revelation summary and a file labeled Epstein flight logs, Clinton lied. In the archive show, his name appears 73 times.
And the flight logs confirm multiple trips on Epstein's aircraft.
They do. But we have to be very precise with the Clinton records. The flight logs confirm his presence on the plane for humanitarian trips to Africa, Asia, Europe.
The unsealed documents also contain that, quote, Bill Clinton likes them young, which is attributed to Epstein.
Yes, but we must distinguish between confirmed presence and a specific criminal allegation within the court records themselves. The unsealed files place him in proximity to Epstein.
But unlike the allegations against Prince Andrew, which detail specific sexual acts, the files on Clinton in this particular release focus more on his association and his travel.
Correct. However, the blanket immunity clause meant there was no federal investigation to stress test that distinction.
And that's the point. Because the investigation was terminated in 2007, that potential co-conspirator clause acted as a preemptive stop.
So we don't have an investigative file from that era that either clears him or implicates him criminally. The mechanism to create such a file, a federal grand jury investigation into the network, was shut down by the NPA.
If there had been no immunity deal, the natural next step for investigators would have been to interview every single person on those flight logs.
You depose the Secret Service agents on his detail. You subpoena records.
But the NPA halted that entire process. So Clinton and others benefited from the absence of an investigation.
The benefit was the institutional silence. The benefit was the lack of a subpoena. Whether he was guilty of a crime or just guilty of a profound lack of judgment in his associations, the legal system never formally asked the question. The NPA answered it in advance. No prosecution.
Then there's Alan Dershowitz.
His name appears 137 times in the Epstein case documents.
Yeah.
And the filings from Jufer v. Maxwell.
And his position is unique. He's on both sides of this.
He occupies a dual role in the records. In 2007, he was a key member of the defense team that negotiated the non-prosecution agreement.
He helped write the very immunity clause we are discussing.
Yes. Then, years later, in the civil litigation, he appears as a named figure in the allegations. Virginia Jufer alleged he was a participant.
Allegations he has vehemently denied.
He has. He's filed countersuits. And in the intervenor documents from that case, we see Dershowitz arguing for the release of certain emails, specifically to prove his own innocence.
He's actively using the court record to try and dismantle the credibility of his accusers.
But structurally, you can't ignore the conflict. He was an architect of the immunity deal, a deal that shielded potential co-conspirators. And years later, he himself is accused of being one of those co-conspirators.
It creates this circular narrative that runs through the files.
It does. Whether he needed the immunity is the subject of the civil suits. But the document trail is clear. It shows he negotiated a deal that said potential co-conspirators are immune, and then years later, that's what he was accused of being.
We also need to discuss Jean-Luc Brunel.
Yes. The Epstein case documents contain a phone messages file. There's a specific entry. Jean 5:14 p.m.
And Brunel is identified in the files as a modeling scout.
His structural role in the enterprise, according to the records, was the supply chain. The documents indicate he was central to sourcing young women and girls for Epstein, often from Europe, under the guise of modeling careers.
This fits the classic definition of a co-conspirator in a trafficking ring.
Without question. He was a recruiter.
So, under the terms of the 2007 NPA, Brunel is exactly the type of person who would have been protected by that any potential co-conspirator clause.
If the government viewed him as a supplier, then he was a co-conspirator. And if he was a co-conspirator, then he was immune.
And the result?
He operated for years after 2007 without facing federal charges in the United States. It wasn't until much later, and largely because of investigations in France, that he faced legal consequences. The NPA bought him over a decade.
He continued running his modeling agencies. He continued to travel. The immunity list effectively erased his liability in the Southern District of Florida for that time.
It did.
Okay, let's address Donald Trump. His name figures in the shocking revelations summary and in the phone message logs.
Yes, entries like Mr. Trump or references to the Katie Johnson versus Trump 2016 lawsuit.
But with Trump, we have to look closely at the flight logs versus the location allegations.
It's a critical distinction in the record. The documents and flight logs show Trump flew on Epstein's plane on multiple occasions. However, the shocking revelations source document notes that the unsealed files reportedly verify that Trump was not present at Epstein's private island or at his New Mexico ranch.
And those are the primary locations of the alleged trafficking operations detailed in the files.
It's a data point that separates his pattern from what we see with some of the other figures who were specifically placed by witnesses at those locations. Presence on a flight, which is transportation, versus presence at the scene of the alleged crimes.
But The potential co-conspirator clause was so broad that it could have technically covered anyone alleged to be involved in any capacity.
Even if the allegations were limited to activity in New York or Florida, the NPA in Florida covered any crimes related to the Epstein investigation. The defense argument was that if the conduct was tied to the Epstein enterprise, the immunity deal could cover it.
That's the global peace strategy again.
It is. So Trump, like Clinton and the others, sat inside that protective bubble created by the legal team. The lack of a federal investigation meant these distinctions were never legally tested.
Okay, moving to a specific cluster of records, evidence block 5. This comes from the Jufer v. Maxwell case, and it concerns another witness, Sarah Ransom.
This section of the record is about the credibility war, the active fight over the narrative.
The document is the Summary of Legal Proceedings, Jufer v. Maxwell. It details a legal intervention by Alan Dershowitz.
Yes, he's referred to as the intervener.
Wow.
He's requesting that the court modify its confidentiality order. Specifically, he wants to declassify a particular email designated Email 5, ransom 0000296.
And the content of that email is graphic. Ransom alleges details about sexual encounters involving Donald Trump and Bill Clinton.
But the reason Dershowitz wants it released is counterintuitive. He's not trying to support her claims. He wants to release it to destroy her credibility as a witness entirely.
It's a documented tactical move.
The legal filing argues that Ransom's testimony is false, inflammatory, and salacious. The defense strategy laid out in this document is to use the sheer audaciousness of her claims against these high-profile figures to argue she is lying about everything.
They're essentially saying to the court, look at these wild claims she made in her private emails. Therefore, you cannot trust anything she says in her deposition.
And it's relevant to the immunity list, because if you can discredit the primary witnesses, the pressure to investigate the potential co-conspirators decreases.
If the accusers are successfully painted as fabricators, the network remains safe.
The document shows the active, ongoing legal maintenance that was required to keep that immunity shield intact. It's not enough to just have the paper deal from 2007. You also have to manage and, if necessary, attempt to destroy the credibility of anyone who challenges it.
And that brings us to evidence block 6. This is perhaps the most significant gap in the entire public record. We are talking about the tapes.
Yes, the Epstein Case Documents Archive contains a list of specific MP3 files, audio files.
The file names are chillingly bureaucratic. Epstein tapes, 2003, own personality, selling strategy, puzzle solver, $1 billion.
The titles suggest recordings made by Epstein himself. They sound like recordings of conversations, meetings, or perhaps even dictations.
And the third batch of Epstein documents released source references the confiscated tapes. We know from other sources that when the FBI raided Epstein's properties,
It seized everything: hard drives, safes, computers.
and the existence of a sophisticated internal surveillance system at his residences is well documented. The wiring, the cameras, it was a panopticon.
So the file names confirm that audio recordings existed. A file named Selling Strategy implies a transactional or business nature to at least some of these recordings.
But here's the discrepancy. We have the file names in the index,
We do not have the audio content, not in the public release.
and the pinpoint database provides a critical piece of evidence here. It shows that the Department of Justice has released and then subsequently deleted certain multimedia files from its public docket.
This deletion pattern is what we call a recorded discrepancy. When a database like Pinpoint, which archives everything, logs a release and then a retraction by the DOJ, it indicates an active management of the evidence.
It suggests those files were briefly accessible or slated for release, and then a decision was made to pull them back.
The Pinpoint database explicitly states that it retained everything the DOJ released, including items that were deleted by the DOJ. So the files exist in that archive, but the official public docket has been scrubbed of them.
And we don't have documentation for why the DOJ would delete these specific files?
We don't have the why. We only have the what. And the what is that multimedia evidence is being handled with a different, more sensitive protocol than paper documents.
And what about the master tapes, the ones confiscated from the safes during the raids?
No transcript, not in any of the unsealed files. The public record contains indices and references to these takes, but the raw audio, which would arguably be the most definitive proof of co-conspirator actions, remains under seal or in FBI custody.
It's the dark matter of this case.
You can see its gravitational pull on all the other documents, on all the legal maneuvering, but you cannot see the object itself.
So let's synthesize what the records have shown us today. The 2007 non-prosecution agreement was not a standard plea deal. It established a zone of immunity.
A zone constructed with very precise legal architecture. It named 4 women, Kellen, Ross, Groff, Marcinkova, giving them explicit personal protection.
But more importantly, it built a perimeter wall around them without any potential co-conspirator clause.
A wall that halted federal inquiry for more than a decade. It prevented the Southern District of Florida, and arguably any other district, from pulling the thread that could have unraveled the entire network.
And when we look at the unsealed documents, the flight logs, the phone books, the depositions, we can see who is populating that zone.
Prince Andrew, Bill Clinton, Jean-Luc Brunel, Les Wexner, they all existed in the safety of that potential status. Because the investigation was capped, their legal status remained alleged or witnessed but never indicted.
And the institutional response is the final layer. The broad drafting of the NPA, the failure to notify victims under the CVRA.
And the sealing and subsequent deletion of multimedia files from the DOJ's own database. It demonstrates a clear pattern of containment.
The immunity list wasn't just a legal instrument.
It was a firewall. It was designed to separate the primary target, Epstein, from the entire ecosystem that supported and enabled him. And for 12 years, the records show that firewall held.
The documented records prove the existence of a formal immunity list for 4 individuals and a functional immunity shield for an undefined network. The identity of those potential co-conspirators can be inferred from the flight logs and phone records, but without federal prosecution, they remain legally protected by the 2007 agreement. We do not have documentation for why the FBI has not acted on the confiscated tapes referenced in the file indices. Next time, victims kept in dark.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.